In this video, we will address and critique the outcome of the cases Masson versus State of Queensland in 2018, the appeal in 2019, and again in 2020. This trial was brought about to question the treatment given by the attending paramedics to Miss Jennifer Masson. In 2002, Miss Jennifer Leanne Masson suffered a severe asthmatic attack that led to irreversible hypoxic brain damage, despite being treated by attending Queensland ambulance officers. Consequently, Miss Masson required full-time care until she passed away in 2016. The plaintiff, the estate of the late Jennifer Masson, decided to hold the defendant, the State of Queensland, responsible for negligence in relation to the decision to not promptly administer adrenaline once severe asthma was recognised by the paramedics. As this event occurred in 2002, the Civil Liability Act 2003 does not apply. The case must be considered with reference to the common law, specifically the tort of negligence. Common law, also called case law, is law that has been developed over time based on previous decisions of the court. A tort is a civil wrong. Civil cases are decided on the balance of probabilities. In order to prove a claim of negligence, 4 factors must be established. Firstly, the defendant owed the plaintiff a duty of care. This duty arises when the risk of harm to others is reasonably foreseeable. Additionally, it must be shown that the care provided by the defendant in carrying out their duty fell below reasonable standard, that the plaintiff suffered damage either physical, emotional, or financial, and that the damage was caused by the defendant's breach of their duty of care. The link between the breach of duty and the damage must not be too remote. When looking at the reasonable standard of care expected of a paramedic, the leading case is Rogers v. Whitaker. The standard of care to be observed by a person possessing special skills is that of the ordinary skilled person exercising and professing to have that special skill. In this case, it would be the standard of care expected of an ordinary skilled intensive care paramedic acting in an emergency situation in the field. The plaintiff alleged that the paramedics owed Jennifer a duty of care and then breached their duty of care when the decision was made to not promptly administer adrenaline, resulting in injury. In 2018, the judge found that the decision to administer salbutamol instead of adrenaline was reasonable in the circumstances, as the paramedics did consider the use of adrenaline but decided that salbutamol was more suitable, completing their duty of care. Amongst the 8 medical expert witnesses used within the case, the decision of which drug was the most appropriate in the case of asthma extremis was disputed. Justice Henry accepted the difference in opinion from the emergency doctors. However, when keeping in a responsible body of opinion in a medical profession, Justice Henry noted that paramedics are not medical practitioners who are specialized in emergency medicine. Paramedics do not work in the same environment as these doctors, and that the standard of care should be decided by other paramedics. Of the 8 expert witnesses, 2 were paramedics and both agreed that as per the QAS CPM 2002 for asthma, salbutamol was the correct treatment. Byrne highlights the inappropriateness of experts outside the qualified field commenting on a matter, stating that you wouldn't get a GP to comment on negligence case regarding a surgical doctor. Additionally, the judge alludes to that if adrenaline was used and the same outcome to occur, there would likely be a case of whether salbutamol was the better decision over adrenaline. Section 5E of the Civil Liability Act 2002 states that the plaintiff always bears the onus of proving, on the balance of probabilities, any fact relevant to the issue of causation. This was not done. Due to the conflicting opinions of the expert witnesses, the judge found that there was no way of working out the exact moment on the timeline from Miss Masson's shortness of breath to the arrival at the emergency department when irreversible brain damage occurred. The case of Masson v. State of Queensland 2019 re-evaluates the actions of the paramedics, specifically Mr. Peters, who was responsible for Miss Masson's pre-hospital care. The Queensland Court of Appeal's findings were similar to the trial hearing, apart from the interpretation of the term guidelines, where the QCA understood the QAS clinical guidelines as protocol. The QCA determined that not administering adrenaline due to the potential side effects was not substantial reasoning to use the inferior drug salbutamol in the context of life-threatening bronchospasm. In accordance with the Civil Liability Act 2003, claims in negligence arise when a person has suffered an injury due to a breach of care from the defendant. Ultimately, the QCA found that Mr. Peters' failure to promptly administer adrenaline was a breach of care and found the QAS was vicariously liable for his negligence. However, following the State of Queensland versus the estate of the late Jennifer Leanne Masson 2020, the High Court found that the QAS officers had not acted negligently, as Mr. Peters did consider the administration of adrenaline, but rejected it due to Miss Masson's hypertension and tachycardia. Mr. Peters' decision was supported by a responsible body of medical opinion in accordance with the Civil Liability Act 2003, Section 22. The paramedic's interpretation of the QAS regimen on the dyspnea asthma was suggested by the plaintiff to be negligent. Mr. Keneally, ambulance expert for the plaintiff, argues that the defendant was correct in identifying the altered level of consciousness with a GCS of 6, one of the indications for the first diamond of the flowchart, but failed to consider adrenaline and/or underestimated Miss Masson's presentation. In response, Mr. Huckers disagreed with Mr. Keneally, as the CPM guides educated paramedics to make a clinical judgment reflective of the patient's presentation. The guideline invited treating paramedics to consider the administration of adrenaline, but does not mandate it. In the Ambulance Service of New South Wales v. Worley, 2006, NSWCA 102, subsection 29, Principles of Liability, it states that paramedics are not medical practitioners, and despite comprehensive training, it does not equip them with the theoretical knowledge which would permit a fine evaluation of alternative treatment. Furthermore, defendant Mr. Peters, the attending critical care paramedic for the Masson case, justified that his clinical judgment reasoning was based upon his own experience and expertise as an ambulance officer. The interpretation of the flowchart by Mr. Peters was justified on the fact that he decided to administer IV salbutamol rather than adrenaline on the basis of Miss Masson's extensive history of severe asthma and clinical assessments. In the 2020 trial proceedings, His Honour reiterated that the trial judge's findings that the QAS Clinical Practice Manual is intended to guide and assist rather than prescribe decision-making. Furthermore, Peters considered the administration of adrenaline, but based on Miss Masson's presenting with tachycardia and hypertension, both contraindications of adrenaline, his clinical judgment was to administer IV salbutamol. Therefore, Peters' decision to administer IV salbutamol was an adequate level of skill required by an intensive care paramedic in 2002, and his interpretation and care for Miss Masson did not fall below the standard of care.